As a real estate agent, we talk a lot about probate, which is when the cows get out of the barn, what happens, how to manage things. But really, as professionals, we're helping our customers avoid letting the cows out of the barn, helping them build a better barn, making sure the barn doors are locked. And using that analogy in our business, that would be make sure customers have evaluated the importance and options regarding estate planning. Really excited to have here today Mark Abell, who is an estate planning attorney based in Canyon Lake, California. If you've never been there, I expect to do some pontoon boating. It's a very easy lifestyle in Canyon Lake. Mark, thanks for joining us today.
Thanks, Bill. I appreciate you having me on some podcast today.
So let's talk about estate planning. I think that there are a lot of reasons why we can see after the fact people should have an estate plan. What percentage of phone calls do you get or inquiries coming into you are people proactively saying, hey, I need to plan ahead, versus what percentage are, oh my gosh, we have a pending problem, can you help us put the fire out?
Yeah, honestly, at this point in my career, I'd say more people are calling me with the latter, saying, oh my gosh, we have a huge problem. We just got served with some papers with the court. We don't know what to do. Right. You know, Dad told us this, but now we're realizing that basically nothing was ever done. So I'm more so focusing on trying to put out a lot of fires.
Right. And I'm just going to do a general rule of thumb that it would cost about 1/10 as much to plan ahead as it is to respond after the fact.
I'd say so.
Yeah. And so also, as a general rule, again, not giving legal advice, I give business advice, but that anybody who owns a house in California should at least review their options of an estate plan. Whether they get a trust or not, that's a different issue. But I would say everybody should at least look at that. Is that a fair assessment?
Yeah, I think so, because it's better to at least get it assessed, evaluate, have an opinion on it, and then especially with just the real estate prices in California. I mean, a lot of the median home prices are exceeding the minimum that you would want to have to do some type of at least minimal estate planning, if not some complicated estate planning. So.
And even with a recent law that was passed that lowers the threshold for some sort of a limited, yet still unknown what it means, still good to have a plan to know where you're going to go or not go, right?
Yeah, because even if you have that, you're still stuck in what we call the intestate succession. And there may be situations like family situations primarily where, not every family has this perfect situation where everybody wants everything distributed equally, and there may be other reasons for that too,
And again, just starting off at a high level, you might have, if you have children, there becomes issues as far as what happens, God forbid, if both parents are gone, who raises them, how they raise, what kind of things are taken care of. So there's another reason for a plan. And then lastly, for when you're not able to make your own decisions, estate plans come into effect there as well, correct?
Yeah, so a lot of people just think, I've told our neighbor or our whoever that if anything happens to me, I want to take care of the kids. Unfortunately, that doesn't work, You need to set up a guardianship. Guardianships are set up as a process of doing like a comprehensive estate plan. And the reason for that is being, the court is actually going to send out an investigator to make sure that these people are capable and willing to take care of minor children.
And I think the people who have that, my next door neighbor take care of that also always includes a couple cats. Just my experience, the same person who has trust the neighbor always has a couple cats. I don't know what the connection there is. I'm not a cat person. I grew up with a cat. I had a cat as a pet where we lived, but I don't know what it is about cats and that kind of idea. Okay, so let's go back to the beginning.
I'm going to advocate for them right now too, now that you mentioned that. So in California, there's actually a specific statute that allows you to create a specific pet trust. So don't just use word of mouth even for your cats.
And I'm not necessarily advocating for cats or against cats. I'm not, my personal feelings towards cats. I am allergic, for the record, medically. But okay, so let's go back to the beginning. Let's talk about estate planning as it relates to real estate. To me, it seems that anytime I'm looking at listing a property, meaning they want to sell a property, and I notice the public records are going to show me it's either deeded as Bob and Mary Smith or the estate of Bob and Mary Smith or the trust, Bob and Mary Smith Trust or something like that. Seems to me that the proper that if it's not held in the estate, not held in the trust, that at least I should ask the question, because if you're selling it and cashing out, that those are substantial assets and there's tax issues. And so tell me why somebody perhaps selling a house and cashing out who didn't have an estate plan might consider doing one at that time.
Yeah, so that's a great question. So I like one thing you mentioned first, that as soon as agents get a listing, please pull a title report and review it. If you don't know how to review it, just contact an attorney. A lot of times you can contact attorneys and just be like, hey, can you take a look at this real quick? If you have a good working relationship, they'd be more than happy to help you out. Let's at least figure out what's going on with it. So once you know what the vesting is like, or I mean, even your title reps too. Right? So once you know what vesting is, then you know who has legal ownership to the title. That's going to create a plan for you to move forward, because you want to have your listing agreement match the vesting. You want to have your contracts match the vesting. You want to have your escrow docs match the vesting. And that's just going to honestly make your whole transaction a lot smoother. It's going to make your escrow agents love you at the end of the day, because you're not going to get to the 28th, 29th day and then say, oh my gosh, we need to rush into court to get letters testamentary or letters, So if it's just in an individual's name and they're alive, it's very simple. If it is in like John Smith, trustee of the John Smith Trust, then you just want to see a certificate of trust, or sometimes it's called a certification of trust or a trustee affidavit. Okay, that just basically verifies that there's a trust, it exists, and that they're the actual trustee who's entitled to manage the assets on behalf of that trust. Okay,
and they have the paper, and they have the paperwork.
Paperwork to document. Yeah. One thing is too, some trust certifications can be created when they initially formed the estate plan, and maybe it's now years later that you're doing the sale or purchase. So you just want to get an updated one too, to make sure that the certification is valid as of the day that you enter into the listing agreement or you sign the real estate purchase agreement. If it's in the name of a deceased individual, if it was held as them as trustee, obviously you want to get an updated certification of trust and make sure that there's no probate that's been opened, and that the successor trustee, so let's say if John Smith owned it, then passed away, that now, John Smith Jr. is entitled legally as the successor trustee to operate under the trust and to list the real estate and sell it. And then if it's an individual that had no estate planning and you think there's a probate that's been opened, then you do want to get letters testamentary. You want to make sure there's a bond in place. You want to make sure that there's no order prohibiting the sale of the real estate or anything like that, because that could just cause a host of issues. And so I'd say at that point, it would recommend at least consulting with a probate attorney that can basically check all those things out for you, make sure that you're not running afoul of any beneficiaries or fiduciary obligations.
I think that just for an action item for those who are watching, the first thing you said, that anytime we list property, in fact, I do before I list the property. As soon as the referral is made to me, my title company will allow me to pull a listing agreement. And I just want to say for the record, today is July 25th when we're recording this, but I literally today closed an escrow that 3 years ago at least, and maybe 4, it came to me as a lead that fell out of escrow because there was a problem with succession. Somebody had died. It was a husband and wife, and the husband had a trust for part of it and didn't for the other part, which went to probate. They didn't realize that. So they got to closing and realized there was an error that was included. And 3 years later, after $107,000 worth of attorney's fees and 3 years of time and multiple escrows falling out, we finally closed it because the original listing agent didn't pull a listing agreement day one. And had they done that, they'd say, stop, we have a problem, let's work on the problem. And the longer it goes, the more, as tough as it is, the longer it goes, the worse it gets. And so I think that that's the best advice ever, is always get a listing agreement before you list the property and make sure you know who cleared it. Because sometimes you get the the prelim. Sometimes you get the prelim and there's the name of somebody you don't know on there. Well, there's a reason why that's there. It's not like the title company is stupid. They're saying there's an old deed that you need to start working on now, and the sooner you work on it, the better. So that's great advice, Mark. Thank you so much. And then also I would say that talk to your local title rep. I've interviewed on this call Kevin Sales and other title companies who are glad to give you tools to pull up records as well as to review the title reports for you. So that's before somebody buys. Before somebody sells. How about when somebody buys? To me, that's a difficult situation because if you're starting your shopping process, maybe you get estate plan done at that time, but buying a house is so time consuming. There's so much paperwork. It's also maybe the wrong time to do an estate plan. So I guess my question for you would be, have you ever had people who are in the buying phase that they want it in place for when they close? To me, it makes sense because now you have an insured title in the name of the trust, but I understand it's difficult. And so even though I encourage people, I very rarely see them fall through on that. Have you seen clients buying a property who didn't have an estate plan during that timing process, and do you encourage that, or is there some other solution you recommend?
Yeah, no, it actually makes a lot of sense to do it that way. I mean, the ideal situation would be we set up an estate plan early on, and then it gets modified as your life grows with family, assets, and things like that. So we can keep it current because life's uncertain and you never know what's going to happen. I mean, you've had strange situations where people you never thought would pass away, and then you get a call and say, oh my gosh, I can't believe that something already happened, but luckily they had something in place. So ideally, you'd want to have it from the get-go. Now, if you are going to basically start to purchase a house and realize, oh my gosh, you sit down with escrow and they're saying, how do you want to vest the deed? And you look at each other and say, I don't know. Single, sole, separate property, husband, wife, joint tenants, tenants in common. You don't know. In California, if you're married, you can also do community property with right of survivorship. If everything's, so you have multiple choices that you can do. I have had people that do want to set up an estate plan right away. And I would recommend that because now for the majority of Californians, right, their home is going to be their primary asset that they have. Appreciation is going at such an accelerated rate over the last decade at least, and even longer, that even if you buy it at the beginning of the year, you're going to have equity in a relatively short period of time, right? So you do want to protect at least that from the get-go. So what I would recommend is, set it up. I mean, it is a hassle, but I mean, you're moving, you're doing a ton of stuff anyways. So oftentimes it just gets pushed off to the back burner. Right. And then you find out people like, oh, well, yeah, we've had it for years. We never actually updated it. We got busy. We started going to baseball practices and stuff like that. So, but I would set it up right away because even if you set up your deeds as joint tenants, tenants in common, community property as right of survivorship, as husband and wife, it's like, well, did husband and wife drive to the escrow office in the same car together? I mean, are they going to drive home in the same car together? Like, that only protects you if one spouse predeceases and one spouse survives. It's by automatic right of survivorship. The surviving spouse will get the property, or however they decide to lay it out as tenants. But if you're both there, now you're stuck in a situation where it's like, well, who's going to get the property? Well, if they don't have anything in place, now we're going through a full-blown probate, and we're going by intestate succession. So,
and it also
take care of it.
I've also been involved in too many probates where people bought a property and then wanted to deed it into the trust, and either they never prepared the deed, they forgot to, or they got the deed, very common, the attorney prepares it to them, gives them a nice little folder to put it in or binder, and they never execute it. They execute it, never record it. And I've also seen deeds were improperly prepared, maybe the wrong APN, maybe the address was slightly typoed or something wrong, or the name was one digit off, or it was a senior, junior situation. And so the beauty of getting it done before you buy the house is then it's deeded and you have title insurance that it is in the trust, which is where you want to go. You're paying for the title insurance anyhow. To get it afterwards is going to cost you money. People don't usually do that, but you might as well benefit from the title insurance you're spending and just get it deeded in. So now this brings up
just on one other point on that. That is a good, I mean, even from my perspective, it's like, hey, if you want to come in my office, I'd be more than happy to put a deed into a trust for you. But I mean, if you don't have to, then just don't, because why would you use the excess money? So if you actually do set it up beforehand and the title company will deed it right into your trust right then and there, it will save you an expense. Because I've also had the opposite situation where people that talk to me beforehand, they deed it into their names individually. Then they come to me like a month later, create a trust. And now it's like, well, now we have to then basically deed this right back into a trust. So you can pay yourself some money up front.
And I don't know how you are, but like, occasionally at closing, I get a large check. I recently got a check for, it's not all my money, but, made out to me. And $300,000 check. And I'm like a little nervous. Like I go right from there, right to the bank to deposit. Not that anybody can really steal it from me, but there's a feeling of heaviness, right? But the house, if you're deeded in your personal names, that's not in the trust, and your intention is to, it's like the attorney is giving you this $1 million asset, and it's kind of at risk until it's put in where it belongs. I just feel like you should get it done the right way if you can. Now, again, some people can't. So this brings up a question I have with attorneys all the time, and I don't give legal advice, I give business advice. My business advice to people is even a bad trust or a bad estate plan that includes a trust is better than none 90% of the time. Now, not 100%. There's obviously outliers and exceptions. So I'd love to get your reaction to that. Even like the scenario I'm thinking of is somebody's buying a house. They don't really have all the time to go through the whole process with you, but at least let's get it done, and then you can amend it. But now the deed is in the trust, and they can always do the rest of the work later and make amendments. So true or false, Again, I'm making a business assessment. You're giving legal advice, I guess, but not too many on the call. A bad or incomplete trust, as long as it's fully done, is better 90% of the time. True or false?
Yes, actually, let me give you my little disclaimer too. So I'm not actually giving any legal advice at the moment. If you do want legal advice, then you'd have to call the office. We have to enter into a written retainer agreement. I'm going to actually go with false on that.
Ooh, okay, let's go. Let's hear it.
So my perspective is that if you put an estate plan in place, it should be an excellent estate plan. It should be a good estate plan that will basically be clear, unambiguous, and carry out the intention of the testators or the settlers, okay? The people that create it. And what I've seen is that if that happens, then things go smoothly. And if you set up a trust-based estate plan, and I'll back up a second, a will-based estate plan would be intended to actually pass through a probate, but in an organized fashion through court supervision. A trust-based estate plan most of the time is designed to pass outside of the confines of probate, be administered basically in an attorney's office and not under direct court supervision. Okay, so if we set all that up smoothly, then that will be taken care of. I've seen a number of, when you say earlier, like, oh, are you getting all these calls for fires to be put out and things like that? I've seen a number of poorly drafted trusts or trusts that did not completely anticipate what the settlors intended, or that there's allegations made that they were done in haste and the individual who executed the documents under duress, undue influence, or other means to cause them to lack testamentary capacity. And what happens then is you usually get a huge letter from an attorney, and then they say, this is what we want to have happen. If we don't happen, we're filing a petition in the court in 10 days. And then that basically takes that and throws you into the court system in trust litigation or will litigation, probate litigation. And then now it's kind of like, well, all bets are off. I've got a case now that was actually filed before COVID, I think 2019. Still litigating that.
So one of the most common misconceptions I get are that if you have a trust, you avoid litigation, or a trust will keep you out of litigation or out of probate court. I say, well, that's just factually not correct. How would you answer that? You must have the same objection.
General matter, I have to look back. I think it's general matter, basically, that is true, because most people that have created a trust have made their intentions known to their families is to, hey, this is what I want to have happen. I executed the docs that will allow that to occur, and everybody's basically on the same page, and all the people are being generally reasonable, and everything runs smoothly. But trust litigation is a growing area of law, just because a lot of people are getting trusts, and attorneys are finding ways to basically attack them and litigate them. Now, are all of those issues going to be legally sound? No. Are some of them? Probably. And a lot of them are just going to be factual disputes between family members that have to be decided by a trier of fact, which would be in probate and trust litigation, would be the judge. So, I mean, a lot of it, most of what I've seen is probably just like family disputes and squabbles that existed during the lifetimes of the people that were never resolved, and they're now being carried out, beyond that. But yeah, so a trust is not necessarily going to avoid litigation. A will is not necessarily going to avoid litigation, and doing no estate planning at all is not necessarily going to avoid litigation, right? And if you have people that want to contest something, they're going to find a way to contest it. They're going to find an attorney that'll probably take on that case, and you're going to end up where you're going to end up. So now we do still put clauses in the documents that are drafted, like no contest clauses. And they basically say, if anybody tries to contest the terms of the will or the trust without substantial justification, that then they would be excluded as if they predeceased, basically died before the individual that created the trust. And if they die before them, then they obviously are cut off and they get nothing. So we do try and put some clauses in there to various efficacy levels of efficacy. But So
It just seems to me if there's enough money in the trust, somebody's going to sue for something. Like it almost feels like, and sometimes you see these lawsuits filed and think, what are they really thinking? Well, the answer is they're just going to squeeze some money out of it somehow, and it's almost like a business decision as opposed to anybody really thinking through the legal case. Is that a fair assessment?
I would say to some extent, to some unsophisticated contestants that think that they're just entitled to something.
Yeah.
However, there are other sophisticated contestants, but a lot of times on the larger trusts and estates, if they are contesting it because of the complexity, if there's LLCs, various parcels of real estate, businesses, things like that, charitable remainder trusts, whatever you have, it's not necessarily readily apparent on the face of the document whether anything has been done incorrectly, right? So if we have a small trust and it's like, hey, the house is supposed to go to son A and it goes to son B, then we know something happened. And that's pretty clear cut. If there's been some type of accounting issue on a complicated trust with a huge business, then that's actually going to take a forensic accountant and an expert to come in and evaluate whether any money was mismanaged and to what extent and to where it actually went to. And then you have to prove whether there was any willful conduct that caused that. So a lot of times what happens on kind of the more sophisticated end is that a lot of money will end up going to the accountants, CPAs, the tax professionals, the lawyers, the tax lawyers, and everything else. So
Yeah. Now, do you do estate administration as well, trust administration, or just a?
And that's a whole other area. So
And you do litigation as well.
right.
So let's talk about the administration part of it. It being the real estate agent, often being brought in to obviously sell the real estate assets. I have a chance to talk to customers sometimes away from the attorney, and it seems like the most common miscommunication is the customer expects the attorney to handle everything, whereas the attorney really is the legal representative, can be the administrator, sometimes is not. But that's a whole separate role and not majority of the time. And the majority of the time, the attorney is just doing the legal stuff. And there's like a little bit of mismatch of expectations. And so obviously the way to combat that is good communication up front, right? And also bring good vendors. Is that something you see when you talk to people who you must call you from other attorneys are upset? He guy did the plan, but he's not doing anything to help me out here. That seems to be a common experience for customers. Their expectations are misaligned with the service they're getting.
Yeah, sometimes that does happen. We try to avoid that with clear communication meetings and followed up with basically, here's what we're going to do, here's what we discussed, and here's what we did. But a lot of time, just to break it down generally, so when you're alive, obviously you can sign away any of your real estate, you can purchase any real estate, you can sign any of the contracts you need to purchase or sell it, and you can also execute the deeds needed to either transfer title out or transfer title in. Once you pass away, however, if you didn't have any estate planning documents in place prior to that, the only way to do that is then to go to a court, talk to a judge. The judge is going to hear testimony and issue an order, and then that order could then be executed by the executor or the administrator of the estate. Okay, so the attorney's role is to basically get the facts from the client, submit the paperwork, and make sure that an order gets issued. Okay, a lot of the times at the end of that, once the order's been issued, that's the extent of the scope of representation usually. Once the order's been issued, that is, and letters testamentary or letters of administration, those documents are then given to the administrator or the executor, and then it's their job to basically walk them from the attorney's office down to the bank and do whatever they need to do with the bank, or down to the real estate agent's office, do whatever they need to do there, or down to the escrow company and do whatever they need to do there. So an estate administration is not an easy job. It's oftentimes an unforgiving job because you're held to a fiduciary standard, and oftentimes it's just an individual that's like, well, mom just died and the 5 siblings nominated me, right? But they're held to a higher standard. But also if you're in an intestate succession where there's no estate plan in place, they are getting compensated for that, right? And usually it's to the same amount as the attorney statutory. And if it's in a trust administration, there's often provisions in a trust that says any trustee other than the people that created it are entitled to reasonable compensation. Okay, we can break that down figure out what that is based on their circumstances, the complexity of the job that they did, and things like that. And there's also private professional fiduciaries that a lot of people don't know about that I'm a big fan of usually because they are licensed by the state. They are bonded. They are usually insured with some type of errors and omissions insurance. And they do this on a day-to-day basis. So oftentimes you can put them in charge and they can make decisions and do things and carry it out in an efficient manner. So.
Well, you gave us a lot. Let me unpack it a little bit. The first thing you said is the administration of the trust or the probate is a job. And I think that's what people don't understand is nobody would do it for free unless they had to, or sense of guilt or responsibility. It's work, and it's the kind of work that I get paid for as a real estate broker. It's very similar, stuff, or you as an attorney, similar stuff. I mean, without the legal part. Somebody you're running your business, if you took all your legal advice, that part of your job, and most people would never do it without getting compensated. And the law actually provides by statute on a probate the same schedule maximum as attorneys get paid, recognizing that it's a lot of work. It's as much work as the attorney. You're going to the same hearings, you're going to whatever discussions there are with the attorney, and then all the rest of the stuff that goes on as well. And so I think you have a choice when you have a estate or a probate estate or trust to administer. Either A, have somebody who's doing it who has the time and the capacity to do it. It's not necessarily the wealthiest sibling because he might be or she might be too busy to manage this extra job they now have. And I do think that more and more in my business, I'm recommending private fiduciaries. I just see that so many people are overwhelmed with the work involved, the accounting and the filings and the need for extra communication. And so I know that for me, I have several I work with and refer business to. And I know as a real estate agent, it makes my job a lot easier. And easier doesn't just mean I'm going to sit around the pool and drink cocktails. It means I can get the job done for the customer more efficiently, effectively at a better price because we're moving quicker like a professional. So I'm glad you kind of mentioned the private fiduciaries. I would urge anybody, if you're a realtor, you should learn more about working with them. And if you're an administrator or executor of a probate estate or administrator of a trust, look into or to ask your attorney or a realtor about fiduciaries that can help you, and they get paid, but they also, now you're not doing that work, you're doing the work you get paid for. And so someone like me, instead of administering a estate, I can sell a house and make more money per hour than I would administering. So it's great material. Now, it's interesting you went to the fiduciaries because the other thing I find about that is there's no job I know of in America that I've come across where there's more of a need and less people available to do the work. Meaning, when I call them, they're all so busy. When I've sought to refer business, they have very narrow niches. They all seem to be pretty much at capacity. I have a good friend who I helped get in the business a few years ago, and he's doing really well. And even he's now trying to get too busy. I'm going to say to him, "You can't tell me you're too busy. I helped you get into this." Is that just me? Is that what you see as well? And then how do you approach the situation of, do you have one you recommend, or do you have a methodology to find the right fiduciary when you refer that?
Yeah, no, that's a great observation. I think that is true. I think that it's basically an area that either a lot of people don't know about or a lot of people aren't going into. But I do find that, yes, there is a shortage of them. A lot of them have been able to get appointed on, I guess what would be the equivalent of like a panel. So their names are listed as potential fiduciaries who would be able to serve if the court needs an immediate appointment. So they get a lot of, some of them that I've talked to get a lot of court appointed work. A lot of them also will have minimum estate thresholds. So, they'll talk to you and they'll say, "Oh yeah, we'd love to help out, but our minimum estate is X. And if it's below that, we're just not going to take it because it's just not going to be worth it." So I think that, a lot of them are filled to capacity. I think a lot of people should explore getting into that career actually. And I think there's just basically just a shortage of them at this point, probably. So.
I think any attorney, anybody who's an accountant, whether you're a CPA or just have an accountancy license, should considering career changes. They're in a niche they don't like. Attorney, you get into family law and you hate family law. This is an area that I think has some wide opportunities and it's very administrative. So you have to be into the details and the accounting and the paperwork and all that. But from a business point of view, it just seemed like there's more business than you could ever handle. And for good people, I mean, like for big estates, I got one. It came to me with $40 million of total assets. I was able to refer it to somebody. because we need somebody good to handle it. I mean, it's not just I'm referring it to somebody. It's like, but if he doesn't do his job, then we're not selling the real estate. I don't get paid. So it's really it hits everybody if they do a good job and creates like a flywheel of more referrals, I think.
Right.
So now I do know that we recently had a law passed in California that purports to break off a portion of probates to streamline the process. It was only for decedents after April 1st, so unless they pass after that, they're not eligible, number one, and then there's other restrictions. And I know of some firms kind of preparing a package for that, kind of like a fixed price, low cost, turnover quickly. Are you aware of anybody who's actually entered that process and passed? Because I don't think the forms are done yet. I can't imagine that the title companies are going to insure the title. I mean, I'm not here to talk anybody out of it, but I'm just saying how that law works. I just can't imagine how that process would work and get through the system. I just don't think we've, as an industry, been able to accept that yet. Have you seen any of those actual streamlined processes or the newer process, AB, whatever it is? I'm drawing a blank on it, 91 or something. Have you seen any of those done yet?
I've taken some seminars on it, some CLEs on it. I'm always leery of anybody that does like a one size fits all, low cost, fast, easy set of forms. So we get something pushed through the court system. Yeah. I have no experience with those forms, and we just, for the most part, just do the size of the estates that I'm working with. Have just been going as long as kind of like life is normal. So. Yeah,
it's an interesting topic, but I don't think it's one of those things where
figured it out pretty quickly here, but.
They should be in a sense. Like I said, I can imagine you could sell the property and then you get ready to close escrow, and the title says, "Well, we're not insuring this because, I have cases where, on a standard probate, maybe a notice of proposed action is not required. Maybe there's one heir, and that's the administrator. And there's no other heirs to notice but the administrator. And the title company will say, "Well, we need to have a notice of proposed action." I say, "Well, the only notice is to the administrator." Obviously, right? But and legally not required. And attorneys will say to me it's legally required, but the title company won't insure it, and either change title companies or browbeat the title company to come around. And this is one of those cases with this new law. It sounds great, but I just don't see it happening unless somebody comes to some sort of a change of heart. Yeah. So so
stepping back also to notices of proposed action are usually pretty much always a good idea, anyways, because so we've got two general types. We have notice of proposed action and probate. Oftentimes those will be court ordered for specific types of assets, real estate, large sales of businesses and things like that. And then on the trust side, you could also do notice of proposed action. And a lot of people, are in the situation you're in. It's like, well, hey, there's just a small asset. We're all getting along now. There's only one person, but the title companies and insurance companies don't necessarily have access to all of the court documents, right? May not have access to all of the trust documents because a lot of times those are private. They're done in an attorney's office, things like that. And so it is usually always a good idea just to do one anyways, even if everyone's on the same page, because if everyone's on the same page, they can just sign off on it. They can do a waiver of it. They can do everything. At least you have a paper trail because you are representing an administrator or an executor or a successor trustee. They are under a fiduciary obligation to keep the beneficiaries reasonably apprised of everything that they're doing and to keep records of basically all the actions that they've taken. And it'll just kind of tick off a few boxes, those. It'll make sure everybody's pretty much at least in alignment, hopefully, because that way they're aware of the transaction before it actually occurs, and it's like, oh, well, I didn't know that the house was selling or, whatever. So usually, even if it is, it's still like a best practice, I would say, even if it's not recommended. We like to do a lot of them. So
it's funny you say that because I have two this week. One is a property that's a trust, so normally would not require a notice of proposed action, but there are some beneficiaries and there's been some objections in the litigation process, and the attorney, to protect the fiduciary, sent out a notice of proposed action. One of the heirs objects, and the problem is this particular property is a duplex where there's two tenants, one in each. It's in a city where they have complete rights. It's not LA, but it's like LA where you cannot get them out unless there's default on their part. So there's nothing you can do to move them out. You can't say you're going to live there. You can't say you're going to redevelop the property. There's nothing you can do to move them out. And now, so you have this property with two tenants, and now we have notice of proposed action with court confirmation. it's tough to get good value for the property when you start layering on these risks. And I'd love to say to the objectors, just, do you realize you're just shooting yourself in the foot? I'll be transparent with the market. I'll be transparent with the contracts. I'm glad to share with you. I'm not cheating you. I'm not representing the buyer on the deal. And we'll pull the money in the bank you can control. But sometimes I feel like the notice transaction gives the objector the sense of power, but they're really shooting themselves in the foot because they don't really know what they're doing with that power.
Sometimes, yes, it can be just an exercise of, you say it's up, I'm going to say it's down. You say it's sunny, I'm going to say it's raining. It just, there are some issues a lot of litigation can end up like that, where it's just whatever you do, I'm going to do the exact opposite.
Right.
It makes it difficult. But that's the nature of the beast.
What are you going to do? It's the nature of some people, and they're just going to fight and fight. And another one I have is a case where it's a creditor who's represented by an attorney, and they're filing to change the administrator. They objected to the administrator for various reasons. And, it was a complicated case, and I tried to explain to her why it took so long. It was in foreclosure. The administrator actually helped borrow the money to get the loan out of foreclosure, which is most administrators couldn't do that. And now we're trying to sell the property. And I'm calling her saying, please don't object to the sale. Like, the money's going to go in the bank account. You can fight over the money. Why fight over the house? You're just going to get less. I don't really care in the sense I'll get paid either way, but why would you want less and force a longer process? And I can't get her on the phone. I've emailed her. It's like, because I know she wants to show her client how tough she is. Like you say, up is down, down is up. They're just going to argue for the sake. And I feel like I do my best to try to help avoid that, but that's a tough part of this business, I think.
And a lot of times too is, you can, there's various tools, like a notice proposed action is just one of those tools. There's also blocked accounts, which I really like.
Yes.
Which are, it's like, look, we have this asset, the market's good now, or the rates are good now, or there's a ready, willing, and able buyer right now.
Yes.
Just deal with that, get rid of that headache, or maybe
Yes.
there's like a lot of deferred maintenance, or I don't know what it is. There's various reasons why you would want to get disposed of real estate pretty rapidly as opposed to keeping it on until litigation continues. So it's like you can sell the asset, have the funds go from escrow wired into what we call a blocked account, which is a separate bank account that funds can go into, but they require a court order to be withdrawn from.
Right.
You guys can fight about everything later once everything's
right.
So.
Fight over the cash instead of the real estate, but don't limit the sale of the real estate while you're fighting, because you're just taking money in your own pocket. The whole process obviously is challenging, and there's emotions and business decisions for all of this stuff. So I try to be mindful of that too. Well, thanks for helping clarify some of that. And then, so you also handle litigation. Now, as an attorney, do you handle litigation where somebody had an estate somewhere else and now they're being, an estate plan done somewhere else, and now they see litigation, or do you only handle litigation on your estate plans that you do yourself?
No, I do handle estate plan litigation for estate plans that others have created.
So hopefully it's because maybe the estate planner missed something or left the door open or didn't lock the door as well. So what are one or two, not drawing on any customers in particular, but I'm just saying in general, what are one or two errors you see in estate plans that make them more at risk of litigation versus if you plan properly, you can help close that door and lock it?
Yeah, a few areas. I would say, generally speaking, if I'm going to divide, we're just speaking in general terms here, the ages of people under 65 and the ages of people over 65. If there's people under the ages of 65, I would say, from my experience, the most common source of litigation is basically just what we would consider errors in the paperwork, okay, or unclear dispositions in the paperwork, okay. So if you get an estate plan, you should read through it. Like before we sign documents, I go through every page with my clients to make sure that they understand it and it accomplishes the goals that they want to have accomplished. So I recommend clients do that well if the attorney's not going to do it for them, because they may catch some issue, right? And they need to discuss that with the attorney so that way they understand it, the attorney understands it, to make sure maybe it is an issue, maybe it's not an issue, right? But there just needs to be clarity on what they're signing. So I would say that's the primary source of litigation, is just ambiguities, or mean, sometimes just outright mistakes or misspellings or something like that. It's a little more rare, but it does happen. Over 65 in the state of California, there's statutes that basically protect for financial elder abuse, financial physical abuse, things like that. And there are increased provisions for damages if somebody does commit financial elder abuse against somebody. And there's other measures that basically the legislature has determined they want to incentivize people from not harming the elderly population. And so over the age of 65, I think you're going to get a lot more cases of allegations regarding that. And then also just because of decline in health towards the end of people's lives, I think you get a lot more allegations of maybe lack of testamentary capacity, undue influence, or things of that nature. So,
I mean, we literally have this discussion with our president of the United States politically, and I'm not saying one side or the other. I'm saying we're having the discussion. One reason is we have older politicians. We also have an older population. That just reflects the population is getting older, and so whether or not they're incapacitated or not, again, no position on the politics. You can make the argument when they're in their 80s, right? It's a reasonable argument to start from. Whether it's true or there's evidence or not, that's to be litigated. But as we get older as a country, I think there's more and more of these situations. It just seems to me more and more real estate cases I come up with, where there's a probate or a litigation on an estate, it's something to do with the age, and then the father has some new girlfriend, or the caregiver became the girlfriend, or the caregiver is, depending on who you are, either the caregiver was a great, nice person and the kids ignored him and he fell in love with her, or she's just a scam artist and has a boyfriend on the side. It just seems like there's just more of those every day.
Yeah. And the legislature, and the California legislature has adopted the statute in the California Probate Code that there's a presumption against caretakers who aren't related by family from taking dispositions of someone that they've cared for that deceased and change their estate plans to provide for them. So.
Yeah, and still people try. I don't know that the word's gotten out to the scam artists. Like the attorneys all know this. But I think, and the problem is that even if you're right legally, right, you can have a client come in and you can show them how the law is in their favor. Once the property's been deeded, perhaps, depending on the situation, I've seen them just deed the property to the caregiver. It's just a problem to get it back out. I mean, it's not like you can be right and the scam artists will go, oh, you're right, you caught me scamming you for your $1 million house. I'll deed it back. What do I need to do? They disappear. They're trying to sell the house. They're trying to get money. And it requires a whole legal process. And so that's why it's important to check these things. And I tell my real estate agent friends, you should be checking your customers' public record information. We have tools title companies give us for free. And if you see a deed that looks odd, bring it to your customer's attention. Hey, I noticed this deed. Is there something going on with your property that I can help you with? Because I know in my case, I had an elderly aunt with a caregiver, and we had some suspicions of what was going on. And I just made a note to check the deed every 30 days just to see, was there anything happening there? It didn't cost anything, but I know she appreciated the protection. So those things I do.
And that's a great thing too. So, I mean, if there is any suspected elder abuse, I mean, obviously Adult Protective Service, public service that's available, people can call and report. And then also, at least I know in the county of Riverside, whenever we record a deed, then a letter comes back basically saying there's been something recorded on title to your property. Like, here's a little document number and a little image of it. Do you recognize this? If so, great. If not, then please call our real estate fraud unit. So a lot of those things are, I think, probably pretty good ideas.
Last question, just because it seems to dominate the business press so much, the changes that are going on in all industries as a result of technology and particularly artificial intelligence. Mm-hmm. Like you, I'm a small practitioner. I'm affiliated with a large brokerage, but my business is really me and my couple, team members and such. And so a lot of these tools are very powerful for big organizations. I find that I use them through companies, like services that I pay for, and they're integrating this technology and upgrading their service as a result. I use ChatGPT all the time. I use other tools all the time, but that's not transforming my business. The software is. For you as an attorney, obviously you can take deeds, take contracts and have them read. You can also have contracts created, but I imagine you also have legal specific forms that do that at a professional level rather than what I would do. How do you see the changes in artificial intelligence as of today affecting your business?
So as I sit here today, I mean, it has impacted the business in the sense that from a legal perspective, there have been a lot of attorneys that have used like a chat GPT, some similar artificial intelligence, and have, I think, experienced what they call like artificial intelligence hallucinations, where it's just creating fake cases or fake citations or improper legal analysis, and they're just taking that. There's been instances, I just read court orders where it's been, I don't know if the allegations are cut and paste, but basically it's somehow been brought before the court and not been accurately verified through one of the tools that we use to basically verify whether a case is still good law, whether the proposition that it stands for is still good law, and whether the legal reasoning behind it is still good law, and has not been overruled in part by another case or subsequently by statute or something of that nature. So to that extent, I know it's caused other attorneys problems. I know there's even situations where monetary sanctions have been issued for filing documents like that. So for me, I think that, I mean, it's an amazing technology. I still have to go through and I do pretty much everything the way I was doing it prior, just to make sure that nothing like that would ever happen, at least from my perspective. And then, but I do think it's advancing so rapidly that it's, you know, it's just hard to say how soon it will actually maybe start really seriously impacting.
I imagine if you're doing estate plans, you use some sort of estate planning software. They have certain templates or different technology, and they're implementing AI into that tool that you're using. So you're not actually using AI directly, but indirectly, it's improving the service that you're able to give your customers, I would think.
It's a possibility. So yeah, I've been a member of Wealth Council for
there you go.
A number of years now, probably a decade, I think. I have to double check that, but for quite a long time.
That seems to be the gold standard of estate planning software when I talk to attorneys. So, well, look, Mark, I know we covered a wide range of topics, and I really appreciate your time today. For anybody who's interested in getting together with him specifically, is the best way to just go to the website and reach out? So you have a phone number there, contact us today link?
Right there, exactly.
So trustabell.com is the website, trustabell.com is the website. And then down below I have his phone number, 310-953-8191, as well as his email, mark@trustabell.com. And if you're not catching this, it's in the description on the YouTube, and otherwise feel free to reach out to me to put you guys together. Mark, thank you so much for your time today. I really appreciate your giving us your insight and explanations, and appreciate your time.
Yeah, thanks for having me today, Bill. Appreciate it.
Thanks so much. And for the rest of you, this is Probate Weekly. We get together every week with leading members in probate business, attorneys, most commonly vendors. Continue the conversation on Facebook at probateweekly.com is our Facebook group. If you have questions, if you're looking for referrals in other states, looking for realtors or attorneys or vendors and such, feel free to catch up with us there. I'm Bill Gross at Bill Gross Probate on social media. Feel free to reach out to me. Phone number, if I can help, 310-210-0008. My contact information is down below. As always, make today your best day ever. Thanks so much.